Okay, I'm pleased to call to order the adjudicatory hearing on the basically MGM, Blue Tarp Development LLC, MGM, proposal for a casino site in Springfield. This is Monday, December 9th, 2013 at 9:30 a.m. Before I started, I wanted to say that I know many people in the room might be anxious to get my reaction to a big story that ran in one of our papers yesterday. I just want you all to know that I am thrilled that Mike Napoli is coming back to the Red Sox. Let me see, I forget the exact, I don't have the exact steps, but I think we start out with the introduction of the attorneys from each side, and then the swearing in of the witnesses. Is that the right process?
Right. Yes.
So should we start out with the attorneys who will be representing who you are and who you're representing?
Sure. Good morning, Chairman Crosby, Commissioners. My name is Nick Castiello. I'm an attorney with the law firm of Fox Rothschild, admitted pro hoc vice. Also appearing from my firm is Pat Madamba, also admitted pro hoc vice.
Good morning, Chairman, members of the Commission. Jed Nozell, also on behalf of Blue Tarp reDevelopment and MGM.
Okay. Anybody else? And for the commission?
Good morning, Mr. Chairman, members of the Commission. David Mackey and Mina Makarios to my left from the firm Anderson Krieger, and we are representing this morning the Investigations and Enforcement Bureau.
Okay, that's it. I don't have this here. And now we need, I think, everybody who will be or might be a witness today to please stand. And raise your right hands. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in your testimony, so help you God?
I do.
Note that all witnesses present respond in the affirmative. Thank you. Right, thank you. Just to be sure everybody is aware of this, this is not like our regular meetings. This is an adjudicatory hearing. We will take testimony and ask questions, and then the commission will take that information and deliberate in private and issue a decision once we come to that. We will not be issuing a decision today or whenever we end our testimony today or tomorrow. Let's see. With that, I believe we start with the applicant, and you're making... Director Wells. Sorry? Oh, Director Wells. I'm sorry. Right. We're going to start with Attorney Mackey.
And before we begin with Director Wells' testimony, I'd just like to note for the record that we have marked 9 different documents as exhibits for today's proceeding. We have the first 4 being the notice of the proceeding, the memorandum that will describe the process for this proceeding, Director Wells' cover letter, and then the suitability report itself. We've also provided to the applicant 5 additional documents that we would like marked and introduced into evidence here, and I don't believe there are any objections to any of those documents.
Is that correct?
I am not certain that I've seen all the documents you're suggesting be admitted. May we confer for a second?
Sure, certainly.
Oh, I'm sorry. I didn't see.
We substituted the one that we had to put a date on. If you guys don't have any objection. Tim does. Yeah, a copy, yes. Oh, he did get a copy of that. Okay. All right.
We have no objection, Mr. Chairman. It's just that 2 of those exhibits don't pertain directly to MGM That's my confusion, sorry.
Okay. Mr. Mackey, anything else?
No, sir, I don't believe there is, though I believe the applicant also had an additional exhibit that it wanted to introduce into the record, and the Bureau has no objection to that exhibit.
Yes, one exhibit, Mr. Chairman. It's a 90-second video.
And I do understand that prior to this, the applicant, has had an opportunity to meet with the Bureau to preview the report and to have an opportunity to have your questions asked and answered for this meeting?
Yes, we did.
Okay. I believe we are ready for an introduction from Director Wells.
Good morning, Mr. Chairman, members of the Commission. It is my pleasure to be here this morning. This has been a 10-month investigation, an extremely comprehensive and thorough investigation. I would like to thank the investigators who worked together on this report. I'd like to specifically here today acknowledge Ted Grove from Spectrum Gaming, Loretta Lilios from our office, and Detective Lieutenant Brian Connors for their efforts. As you're aware, given that you have received and reviewed the completed report, this is an extremely comprehensive analysis, and as such, I will not be addressing every point contained in the report since you have already reviewed it. Instead, I'll attempt to hit the significant areas, recognizing that the applicant, who's before you here today, will be providing details to the Commission directly. The applicant before us here today is Blue Tarp reDevelopment, LLC. I would like to initially compliment the applicant here today for their cooperation in the investigation. As I stated previously, this was 10 months of interviews, document requests, further interviews, further document requests, and at all times they were cooperative, compliant, willing to work with the IEB in the process, and we found that it was an extremely successful endeavor working together with them on that investigation. I believe that's indicative of how they would cooperate with the Massachusetts Gaming Commission going forward. Blue Tarp reDevelopment, LLC is owned 99% by MGM Resorts International and 1% by Paul C. Picnelli, a natural person qualifier. MGM Resorts is a publicly held company. Its primary business is the ownership and operation of casino resorts. It operates 15 in the United States. Its primary venue is Las Vegas. They also have casinos in Michigan and Mississippi and have interests in other domestic casinos. They also conduct a significant business from MGM Macau, a special administrative region in China. MGM Resorts International holds 51% of the common stock of MGM China Holdings Limited, which wholly owns MGM Grand Paradise, the owner-operator of MGM Macau. The scope of licensing process determined the additional entity qualifiers and other subsidiaries identified in the report, including Tricinda Corporation, which holds an 18.6 ownership interest in the MGM Resorts International, as well as Dubai World, which holds a smaller ownership interest and has a seat on the board. Additionally, Rolling Hills Estates Realty Trusts were identified as a qualifier along with individual and entities given their contractual agreement with Blue Tarp for a portion of the annual gaming revenue in perpetuity. In all, the Blue Tarp application consists of 13 entity qualifiers and 36 individual qualifiers, all whom were vetted and investigated. The investigative report identified 3 issues pertaining to the applicant's suitability, as described in my cover letter: the Christensen matter, matters relating to MGM Macau, and a matter involving individual qualifiers Vincent Barletta and Ronald Gillis relating to the preparation of Barletta's application. It should be noted that Barletta and Gillis are only contractually related to the application, so they are separate from the MGM group here today. By identifying these issues, the IEB does not suggest that the Commission is limited in asking questions to those areas. In fact, the Commission is free to inquire as many areas of concern that any Commissioner may have, as this Commission has done with the other applicants. Blue Tarp proposes to build and operate a casino gaming facility utilizing approximately 14.5 acres of land over a multi-block area in Springfield, Mass. The planned casino includes a 25-story hotel with 250 rooms, 125,000 square feet of gaming space, integrated residential, retail, dining, and meeting space. The projected cost is approximately $800 million. The MGM officers required to qualify included James Murren, Corey Sanders, William Hornbuckle, Daniel DeRigo, John McManus, Robert Baldwin, Phyllis James, Christopher Nordlund, William Scott, Rick Arpin, James Freeman, Alan Feldman, Sean Sanney, Robert Selwood, Larry Medford, and Thomas Peterman. The investigation reviewed, which are detailed in the report, significant acquisitions by the company, significant litigation, media coverage, compliance history, their compliance plan, and their compliance committee procedures, anti-corruption guidelines, and anti-money laundering policy. As I indicated earlier, there were 3 issues suggested to be discussed by the commission. The first one is the Terry Christensen matter. Terry Christensen was a member of MGM Resorts International Board of Directors from August 1987 until February of 2006. He resigned from the board at the insistence of New Jersey regulators following his federal indictment on illegal wiretapping and aiding and abetting charges. He was convicted in August of 2008. Despite his indictment, resignation from the board, and subsequent conviction, senior executives at MGM and Trescinda continued to interact with him, including on sensitive and non-public company matters. His involvement ended on September 29, 2009, after the intervention of New Jersey and Nevada regulators. Regulators in New Jersey and Nevada requested that MGM and Trescinda provide a written report. Accordingly, corporate counsel conducted a comprehensive internal investigation. The facts of the Christensen criminal indictment are detailed in the report and are obviously very troubling. As the prosecution presented evidence that Terry Christensen paid an associate at least $100,000 for a wiretap of Kirk Kerkorian's wife during divorce proceedings, and the surreptitious recordings not only included extremely personal information, but also included litigation strategy between her and her attorneys. I won't review the facts of the investigation as they are detailed in the report. However, some are particularly notable. For example, when Terry Christensen resigned from the board in February of 2006, MGM issued a press release expressing confidence in his eventual exoneration. Sworn interviews indicated that there was no independent review of the criminal allegations prior to the issuance of the press release. On March 31st, 2006, the MGM Compliance Committee convened and reported to the Compliance Committee. The Compliance Committee unanimously recommended at that time that, number 1, MGM should advise the Christensen firm to remove Terry Christensen as a billing partner on the MGM account. 2, Terry Christensen cease any further involvement in any litigation for MGM. And 3, the Christensen firm adopt a policy prohibiting Terry Christensen from being consulted on any matters relating to the law firm's representation of MGM. Later, individuals indicated that a telephone call was received from either Gary Jacobs, the general counsel of MGM at the time, or Bob Face, senior partner with Lionel Soren Collins, asking the Compliance Committee reconsider its recommendations as they were too harsh and would be detrimental to MGM. The Compliance Committee reconvened on May 5th, 2006, and Face addressed the committee at Jacobs' invitation. It was explained that Christensen's institutional knowledge was valuable and precluding MGM from obtaining his advice, that precluding MGM from obtaining his advice could substantially harm the company. The Compliance Committee then altered its recommendations, deciding, number 1, Terry Christensen should remain as billing partner on the MGM account. 2, it was acceptable for MGM to use Terry Christensen's legal services from time to time on matters of importance. 3, it would continue to the condition that Christensen cannot act as lead litigation counsel. And 4, added a condition that MGM prepare and submit quarterly report on the status of Christensen's indictment and the amount of services he provided during the preceding matter. Specific examples of Terry Christensen's continued involvement on MGM can be found in the report starting at page 83 and proceeding. Notable is that he attended approximately 4 board meetings, and he was present on a telephonic meeting or meetings, and other board members were unaware of it at the time. MGM relied heavily on the advice of then General Counsel Gary Jacobs, that it was permissible to have continued contact with Terry Christensen, despite the fact that Jacobs and Christensen were law partners and friends for decades, an obvious conflict of interest. I could go on in detail about the concerns in the report. However, during the course of the investigation, no one at MGM disputed the facts or argued that the behavior was somehow acceptable. Rather, MGM executives readily admitted that the whole Christensen matter was not handled properly and there was a black mark on the company's history. The investigation then focused on the remedial actions of the company following the Christensen matter. The applicant is prepared today to review those remedial measures with the commission, so I'll leave it to them to explain the details of those. Overall, I expect them to explain the changes in policies and protocols with respect to the Compliance Committee, training, and other matters related, including the resignation agreement with Gary Jacobs. A review of actions of other jurisdictions with respect to the Christensen matter showed in 2010, Michigan brought an action against MGM Grand Detroit for failure to provide written notification to the MGCB of the Christensen indictment. They had a $150,000 penalty. $75,000 was held in abeyance pending a one-year probationary period, which they successfully completed and not have to forfeit that financial money held in abeyance. In 2013, this year, Maryland found that MGM qualified for licensure, but required as conditions they not have contact with Terry Christensen. And this year, 2013, the state of New Jersey's investigation is pending. They actually work collaboratively with Massachusetts on this piece of the investigation. Now turn to the information contained in the report regarding MGM Macau. There's a lot of significant information contained in the report. Given that we're looking to hear from the applicant today, I won't go into too much detail on those, but I would remind the commissioners of a significant amount of detail in the report for consideration during deliberations. A significant portion of MGM Resorts' international business comes from its operations in Macau. Overall, it has been a financial success. Macau is the top grossing gaming jurisdiction in the world. To understand the concerns surrounding gaming operations in Macau, it is important to differentiate between pre- and post-1999. It has been widely acknowledged that in the 1980s, Asian organized crime groups known as triads became prominent in the junket operation of Stanley Ho's casino monopoly at the time. Triad presence remained high throughout the 1980s and the 1990s. In the period 1995 through 1999, large-scale violence erupted between rival Macau-based triads vying for the lucrative junket operation market and its related activities. During this period, Hong Kong-based triads also moved into the area. In December 1999, pursuant to a treaty between Portugal and China, Macau reverted to Chinese sovereignty and became a special administrative region of the People's Republic of China. Casino gaming remained legal in Macau while illegal in the PRC. China took strong measures to curtail triad violence in Macau, including dispatching its army to Macau and executing and imprisoning triad members. At that time, there was immediate and drastic drop in violent crime. Since 2000, a period in which there has been a dramatic rise in gaming-related revenue in Macau, Macau has continued to experience a significant decline in violence. Nonetheless, concerns about organized crime persist. In 2001, the government opened a bidding process for 3 gaming concessions. Those concessions were granted SGM, Wynn Resorts, and Galaxy Casino. SJM is owned by STDM Stanley Ho's company. In 2005, SJM sold a sub-concession to MGM Grand Paradise in a partnership between Pansy Ho, Stanley Ho's daughter, and MGM Resorts. There's more to follow on the Pansy Ho matter. I'll address that shortly. In December of 2007, MGM Macau entered into operation. Currently, in the Macau game regulatory structure, there are 6 autonomous licenses operating approximately 35 casinos. 3 of these are U.S.-based operation: Wynn, Sands, and MGM. A significant portion of the Macau gaming market is comprised of high-stakes patrons from the PRC who almost exclusively play baccarat in dedicated VIP gaming rooms. VIP gaming rooms are well-appointed suites generally located within a large casino that provide luxury accommodations and privacy exclusively for gaming by top-tier gaming patrons. The gaming promoters rely on a network of collaborators comprised of junket operators, subjunkets, and agents. This structure looks like a pyramid as you go down the chain. A paramount benefit offered by gaming promoters is the ability to extend credit to mainland Chinese players, which the casino will not do because gambling debts are not legally enforceable in China. Further, the casino cannot advertise or market the gaming aspects of its casino in mainland China, that is unlawful there, and it relies on the gaming promoters to accomplish this. MGM Macau is 8 of these gaming promoters. Although U.S. casino concessionaires doing business in Macau maintain control of the actual games, the gaming promoters are responsible for certain cage, cash transaction, reporting and credit issuance, and collection functions. Extremely notable is that while the official gaming promoter is licensed by the DICJ, the Macau Gaming Regulatory Authority, the licensing and vetting requirements do not extend to the network of collaborators, subjunkets behind the gaming promoter. As outlined in the report, there exists concern that because this network is not subject to licensing and vetting, there is an increased risk that criminal triads or other unsuitable persons may infiltrate or resume a foothold in Macau's casinos through this collaborator network. It is the role of the gaming promoter, not the government, to determine the suitability of the gaming promoter's partners. The United States-China Commission report, which was recently released, acknowledges ongoing concerns about organized crime in Macau casinos today. Although it should be noted there are differences between the U.S.-based casino operations and other casino operations, and the USCC report acknowledges that. As detailed in the report, these concerns I have mentioned remain about the potential susceptibility of gaming operations to this involvement by unsuitable persons. There has been no suggestion in the investigation that MGM would knowingly associate with unsuitable persons. However, it was with this backdrop that MGM sets its practices with respect to the scope of due diligence it considers to be commensurate with the known risks in Macau. And that is part of the reason for the discussion here today. As to the MGM Macau gaming promoter system, as I stated previously, MGM Macau has 8 gaming promoters. MGM Macau supplies all the game personnel, such as dealers and game supervisors, as well as security personnel and surveillance monitoring. However, consistent with Macau's legal and regulatory scheme, the cage or financial center of that gaming room is operated exclusively by employees of the gaming promoter. The promoter is also responsible for anti-money laundering efforts. MGM does provide training to the AML coordinators in these gaming operations rooms in the gaming promoter VIP rooms. The gaming promoters are responsible for recruiting and supplying gaming customers to their respective rooms. This is accomplished through this network of collaborators and subjunkets. Depending on the size of the gaming promoter's operation, there may be multiple levels of these collaborators and subjunkets, numbering in the many hundreds or even 1,000. MGM Macau advances credit in the form of non-negotiable gaming chips exclusive to a particular gaming VIP room, which are then advanced to the customer through the collaborator distribution system. MGM Macau is not involved in the gaming promoter to customer credit issuance and the collection process. There are MGM Macau policies applicable to credit for their mass gaming floor and in their own high-limit gaming rooms, but they are not applied to these gaming promoter rooms. This credit system comports with DICJ regulations. Nonetheless, MGM Macau is unaware of the manner in which credit is extended to and collected, therefore not aware of the interest rate, if any, is charged, or the manner in which debt collection is undertaken in a jurisdiction that does not recognize gambling debts as legally enforceable obligations. The USCC annual report cited a 2007 University of Nevada study that stated the extent to which extra-legal means of debt collection, i.e. threats, intimidation, violence, etc., occurs is an obvious concern for regulators, especially those from outside Macau that oversee companies which are concession or sub-concessions holders in Macau. Investigators reviewed the due diligence that MGM Macau performs on their gaming promoters. That is detailed in the report. And I expect that Larry Medford and Grant Bowie may address the commission on that. While the MGM Macau does due diligence on the promoters, does not conduct due diligence on the collaborators, citing the overwhelming numbers, it also does not rank the collaborators and do due diligence on the top level of the pyramid below the promoter. But it should be noted that is not required by the Macau government. Based on the investigation, MGM's procedures continue to evolve, even based on our inquiries and the collaborative efforts between investigators and folks at MGM. MGM executives have consistently been forthright, acknowledging the history of triad involvement in Macau's casino industry, as well as acknowledging legitimacy of ongoing concerns about triad infiltration. Macau is fully compliant with DIC's regulatory requirements, as not only at times gone beyond what the DICJ requires, but has expressed a willingness to adopt additional measures in order to satisfy its own concerns about the anticipated, and its own concerns, as well as the anticipated concerns of domestic regulators. Just now going to turn to the section in the report which deals with the MGM's partnership with Pansy Ho. In the early 2000s, MGM desired to enter the burgeoning Macau gaming market. Originally, they considered an opportunity to operate under SJM's concession, whose entities were connected to Stanley Ho. MGM abandoned that idea after Nevada regulators raised concerns about Stanley Ho's suitability, given that Stanley Ho had long faced allegations of business ties to persons associated with organized crime. Instead, MGM proceeded with a partnership with Pansy Ho, Stanley Ho's daughter, and obtained a subconcession from Stanley Ho's SGM in 2005 in exchange for a one-time payment of $200 million. The resultant MGM Macau opened in December of 2007. In 2007, Nevada regulatory authorities issued a finding of suitability for MGM's association with MGM Paradise Limited. In 2009, New Jersey DGE issued a special report on its investigation of MGM's partnership with Pansy Ho. The DGA recommended that Pansy Ho was unsuitable, mainly out of concerns that she was acting as a front for her father. It should be noted that she was not a qualifier before DGE at that time. The DGE report is attached. The Massachusetts report is an exhibit. It is a public document, the redacted version, so I will not recite at this time all the facts and findings in that report. The matter was never subject to a hearing before the New Jersey Casino Control Commission, as MGM entered into a stipulation of settlement with New Jersey regulators. This required a withdrawal of the MGM casino license, no admission of culpability by MGM, and required the sale by MGM of its 50% interest in the Borgata. I believe that was allowed to be put into a divestiture trust. Terms later amended to allow MGM to reapply in New Jersey, which it did in February of 2013. That application and investigation is pending now. Pansy Ho's status as an equal joint venturer changed in June of 2011 when MGM China Holdings went public on the Hong Kong Stock Exchange. MGM went to a 51% majority interest, and Pansy Ho's interest was reduced to 29%. Additionally, Stanley Ho's health is greatly deteriorated and is believed he is not physically or mentally able to influence his daughter with respect to MGM Macau at this time. Pansy Ho was interviewed as a part of this investigation and denied that in gaining her concession with MGM, she operated under her father's influence. That position is consistent with her testimony before the Nevada Casino Control Commission, but inconsistent with the DGE special report. As to financial suitability of the applicant, details contained in the report and our financial investigators confirmed that MGM Resorts International has the financial resources and stability to support the casino project before you here today. As I indicated, MGM Resorts International has a 99% interest in Blue Tarp redevelopment. The other 1% is owned by Paul Pignelli. The investigation did not reveal any derogatory information which would impact his suitability for licensure. As I indicated, there were other entity qualifiers based on their percent of ownership of the MGM stock, including Dubai World. Investigators at Spectrum completed a separate report regarding Dubai World, which was attached for your consideration, and their related entities and natural person qualifiers. Generally, the investigation did not reveal any derogatory information that would call for a finding of unsuitability with respect to this application. Investigators confirmed that Dubai World was found suitable by gaming regulators in Nevada, Michigan, and Mississippi, and no adverse actions exist in those jurisdictions. An application before the gaming regulators in New Jersey was withdrawn in 2010 as part of the Pansy Ho issue I described before, as part of the settlement agreement previously described, and a reapplication is pending. The report also details the investigation into the Trecinda Corporation, also investigated issues pertaining to the Christensen matter should be noted in that part of the report. In addition, the investigators completed an investigation of Rolling Hills Real Estates Realty Trust, as well as their additional entity qualifiers and natural person qualifiers. It was deemed a qualifier because it has a contractual right in perpetuity to receive monetary payments from the gaming revenues of the proposed casinos. It also receives 2 success fees. There are 2 trustees and managing partners, both qualifiers on the side of the trust, the David J. Callahan and Vincent F. Barletta. That goes into the Callahan group is the entity is the Cal Rolling Hills. That includes David Callahan, Janet Callahan, Charles Callahan, John Callahan, and Julie Callahan, all determined to be qualifiers. On the Vincent Barletta side, aside from him being a qualifier, the VFB Dynasty Trust, Vincent F. Barletta, Ronald Gillis, Timothy Barletta, and John Bowman. As to Vincent Barletta and Ronald Gillis, as is detailed in the report, on Vincent Barletta's application, the investigation determined that it contained factual errors. He answered in the negative whether his driver's license had ever been suspended, when in fact it had been suspended on 5 occasions. And 2, he had answered that he had graduated from Northeastern University, when in fact he had not. He admitted in his sworn interview he had Ronald Gillis fill out the form, who had placed Barletta's initials on each page. Barletta then signed in the statement of truth, but did not review the completed application for content or accuracy. Gillis also signed Barletta's name on the waiver of liability release form. This form was then notarized by Gillis himself, who as a notary attested that the signature was Barletta's. Gillis indicated he was under pressure to complete the form by a certain time, and Barletta was out of state at the time the document was completed. In addition, Timothy Barletta was initially identified, as a qualifier. However, the investigation revealed a statutory disqualifier for him. This is not being contested by Mr. Timothy Barletta, and according to his attorney, his interest is going to be bought out, therefore eliminating his perpetuity interest in the gaming operation. Therefore, there's not a contested issue before the hearing today. The IUB will update the commission as appropriate in that matter, but we can take care of that issue. With respect to the Barletta and Gillis issues, there is a contractual remedy with Blue Tarp if there are suitability problems, and the IEB recommends that any action by the commission be consistent with that contractual remedy, and we can provide documentation as necessary for the commission's consideration if that becomes an issue. Ultimately, the IEB recommends that the commission find the applicant, Blue Tarp redevelopment, suitable for licensing, subject to the following conditions. Number 1, the applicant should satisfy the commission at the hearing today that the applicant's and relevant qualifiers' response to the Christensen matter and subsequent remedial measures adequately demonstrate the applicant's and relevant qualifiers' suitability under 23K. 2, the applicant should satisfy the commission at a hearing that the applicant's business practices in Macau meet the statutory requirement of responsible business practices in any jurisdiction. And 3, the applicant should present evidence at a hearing to satisfy the commission that Vincent Barletta and Ronald Gillis meet the statutory criteria for suitability, given the concerns outlined in the report. So that completes my summary of the report for your consideration. I'm available for any questions by the commission. I also have Detective Lieutenant Connors, as well as Ted Grove here, if the commission has any questions on the report. Otherwise, I'll turn it over to the applicant, because I know there are several witnesses prepared to discuss the issues here today.
Commissioners?
I just had one question about the Dubai World piece.
Okay.
There are, and it's not a factual question,
Okay.
it's a policy question. There are a number of recommendations that you make in the cover letter, but as I understand it, the essence of the matter is that the commission be provided with information on a continuing basis to show that it is not the government of Dubai that is in charge, but it is the entity to which it is delegated operation of Dubai World. Is that a fair summary of?
Well, I think that the delegation of authority question, they specifically, and Ted may be able to explain this a little better than I can, but the delegation of authority, it's a very large company, and related to these issues connected to MGM, there's a delegation of authority here. So that was the matter I was
Right.
trying to address.
And the IEB recommends that the commission be provided with information on an ongoing basis to
Yeah.
assure that that delegation remains in place.
Yeah.
And in fact is and in fact that the delegates, as opposed to the government, is running the operation.
That's correct. Is
And
that fair
that's
to say?
to,
Yes.
and that's to assure that a qualifier and licensee of the commission, a qualifier of the commission is in fact in charge, so that the commission can enforce, if it needs to, appropriate the gaming concession appropriately.
That is correct. There
Okay.
also, I did receive an email from one of the attorneys for, that with connection with Dubai, where there's some modifications, just procedural on how to get that information to the commission, which I have no objection to, and I'll submit that in writing to the commission.
All right. I was just trying to
Yes.
make sure I understood the
Yes.
big picture there.
You do,
All right.
yes.
Thank you.
We're going to be coming back to the Dubai World issue, I think.
Oh, at any
right?
time,
So,
you know.
Yeah, so, because I had some related questions, but I think I'll wait until we
Okay.
get into the topic.
Okay.
Anybody else? Okay. Sir?
Good morning, Chairman Crosby, Commissioners. We appreciate the opportunity to be here today to present evidence on the suitability of a Blue Tarp redevelopment with respect to its Category 1 application for a proposed project in Springfield, Massachusetts. I will be brief, and I know when you hear a lawyer say that, you cringe, you're not going to believe me, but I will be brief. So let me start off with some introductions. MGM will have 5 witnesses testify today. They are Jim Murrin, the chairman and CEO of MGM Resorts, who is seated to my right. To his right is Roland Hernandez, the lead independent director of the Board of Directors of MGM Resorts. To his right is John McManus, the executive vice president, general counsel, and secretary of MGM Resorts. And in the second row, we have Grant Bowie, who is the CEO of MGM China Holdings Limited. And seated to his right is Larry Mefford, Senior Vice President of Global Security of MGM Resorts. They will be available all day, of course, to answer whatever questions you have. However, Mr. Hernandez requests permission to leave by 12:30 today. In addition to the witnesses, the following qualifiers of MGM are here today. Bill Hornbuckle, who is President and Chief Marketing Officer. Dan Dorigo, who is Executive Vice President and Chief Financial Officer. Tom Peterman, who is Senior Vice President and Chief Compliance Officer. And Mike Mathis, who is Vice President of Global Gaming Development for MGM Resorts. There are other representatives of MGM here today, but I will spare you all the introductions. The November 27 letter from Director Wells to you recommends that MGM be found suitable subject to 2 conditions. One condition is that the applicant satisfy you that the response of it and its individual qualifiers to what the report refers to as the Christensen matter and the subsequent remedial measures demonstrates their suitability. We will address that through the testimony of 3 witnesses. Roland Hernandez, the lead independent director of MGM Resorts, will testify regarding his supervision of the independent investigation and the response of the company as chair of a special committee of independent directors of the board of MGM. Then Mr. Murren, the CEO, will address his role in the Christensen matter. And then lastly, John McManus, the general counsel of the company, will address the compliance plan of the company with an emphasis on changes that have occurred in response to the Christensen matter and more recently as well, and other responsible business practices of the company. The correspondence of Director Wells also asks that we satisfy you that the company's business practices in Macau are responsible as required under the statute. We will have 2 witnesses testify on that subject. They are Grant Bowie, the MGM China CEO, and Larry Medford, the Senior Vice President of Global Security and former Executive Assistant Director for Counterterrorism and Counterintelligence of the FBI. Before I ask Mr. Murren to say a few words about the company, we would like to show a brief video because a picture is worth 1,000 words and it's going to save time. Thank you. Mr. Murren's now going to testify a little bit about the company, then Mr. Hernandez, and then we'll go back to Mr. Murren if that's acceptable. Jim, please tell us about the company.
Well, thank you, and good morning, everyone. Chairman Crosby, members of the commission. Can you hear me there?
And you're in back?
Can you hear me?
No.
Doesn't sound like so. Let me take this one. You can hear me now?
That's good. Indeed, yeah.
Thank you. Good morning. It is an honor to appear before you today representing the men and women of MGM Resorts. We thank the Commission for its professionalism through this process, and I'd also like to recognize the efforts of Director Wells of the IEB and Detective Lieutenant Brian Connors of the Massachusetts State Police, and all of those who report to them, as they have, in fact, worked tirelessly to complete the investigation of our company and have been very cooperative and helpful through this process, so thank you. I'd like to start by telling you a little bit about our company. I am proud to be the chairman and CEO of MGM Resorts. It is a highly dynamic and exciting company, a Fortune 500 company with annual global sales of over $9 billion and more than 60 million customers in our database. We are listed on Fortune magazine's America's Most Admired Companies, included on Forbes' Platinum 400 list of best managed companies, and cited as an employer of choice by Diversity Inc., Black Enterprise, and several other prestigious publications. We have been recently noted as a top employer of undergraduate and MBAs, and for the third year in a row. We employ about 62,000 men and women, and I know we're sometimes considered a casino company, but I think that would be a bit misleading. And in fact, over 70% of our revenues in Las Vegas alone come from entertainment and hospitality. We operate over 42,000 hotel rooms, and our properties are known for their selection of fine dining. We offer food of every possible culture and palate, from celebrity chefs and up-and-coming culinary talents, and we have almost 400 different food and beverage venues in our portfolio. I know that Las Vegas is known as the leading destination for conferences and conventions. Our company alone operates more than 3 million square feet of convention space. That, by the way, is more than exists in all of New York City, which I'm sure you're happy to hear. And perhaps more than anything else, MGM is known for its entertainment. We operate 2 arenas on the Las Vegas Strip, and we're developing yet a third in a joint venture with AEG. Both of our current arenas feature the most sought-after performers in every style of music. Basically, any rocker over 50 plays at the MGM. The Rolling Stones, Aerosmith, the Eagles, and then the youngsters, Justin Timberlake, Beyonce just recently, and of course the iHeart Music Festival is always held at the MGM. And if you're a sports fan, there are of course UFC and college tournaments of every type, as well as exhibition NBA and NHL. And if you want to see Floyd Mayweather, you have to go to the MGM because that's the only place he's ever fought. And in fact, if there is a boxing match you've seen of any significance in the past 20 years, we were probably your host. You may also know that we have a historic relationship with Cirque du Soleil. We've been proudly their partner for over 20 years. But more importantly, I believe, the men and women of MGM are committed to a set of core values that define who we are and what we do. Teamwork, integrity, and excellence. Those are the values that tie us together. They drive our important initiatives in areas such as diversity and inclusion, philanthropy and community engagement, and environmental responsibility and sustainability. We have a board-level corporate social responsibility committee that is chaired by former U.S. Secretary of Labor Alexis Herman. We also have an executive social responsibility committee that's internal to our company, and it is the only internal committee that I chair because it is so essential to our company. We believe CSR should not be a department, but ingrained into everyone's job to support and advance these initiatives. Diversity is in our culture, and in fact, MGM was the first company in our industry to formally adopt a diversity program. We are a majority-minority company, and that diversity, we believe, is our strength. Of our employees, approximately 64% of them are minorities. Currently in the management ranks, 43% of our employees are women. The men and women of MGM come from literally all parts of the globe, speak dozens of languages, and represent almost every imaginable race, religion, sexual orientation, age, education, and life's experience. And I'm proud to announce that just today, we have again received a perfect score on the Equality Index by the Human Rights Council. We train thousands of employees every year on the importance of respecting and embracing our differences. Over the past decade, MGM Resorts has spent nearly $1.5 billion with minority-owned and disadvantaged business enterprises through construction, design, and other professionals. And through our employee-funded MGM Resorts Foundation, our employees have donated more than $50 million to community charities and organizations over just this past decade. And recently, the governor of Nevada awarded our employees with the state's Points of Light Award because our employees volunteered over 113,000 hours to charities last year alone. And with the American Red Cross, we are doing something to help our nation's veterans return from their service to society. We have developed a program called Boots to Business. It is a 12-week management training and development program in which the American Red Cross, through its Service to Armed Forces mission, identifies and prepares veterans into junior management positions, and MGM interviews and hires these veterans and provides them with management training. We've hired many veterans recently in this program. MGM is also a leading green company. We've pioneered leadership through sustainability efforts by incorporating power and water conservation, recycling, and other green practices into our daily operations, and we've been doing so for years. As you know, the Massachusetts gaming law requires developers to build to a LEED level of gold. This is good. We're the only applicant that has done this, and we've done it on an unprecedented scope and scale. The most profound example, perhaps, is City Center, an integrated resort at the heart of the Las Vegas Strip that is the world's largest environmentally sustainable mixed-use construction development. It has received 6 LEED Gold certifications from the U.S. Green Building Council, 6. It has its own cogen plant and operates, we believe, minimally at a 30% greater efficiency than comparable resorts. In fact, we've reduced our consumption of energy enough to power about 40,000 homes a year, and as much water that flows over Niagara Falls in an entire hour. And I want to recognize our partner, the city of Springfield. I've come to enjoy and love this city, a great American city that, as you know, in recent years has fought through all kinds of challenges. A once thriving city, pummeled by the economy, and adding insult to injury, a tornado that ripped through its downtown in 2011. I've met with many people there, led by Mayor Sarno, and I've learned of the resiliency of the people there and the belief that they can pick themselves up as they have time after time. And I believe that Tim Rook, who is a city councilor from Springfield, is here today. I think he braved the elements to get over here, so thank you, Tim, for doing so. As you know, on July 16th of this year, the citizens of Springfield overwhelmingly approved MGM Springfield to be a part of that recovery. And I believe that we can be a part of the urban renaissance. And I think it's a responsibility that we should take very seriously, and we are. And we thank them for reaching out and embracing us. So on behalf of the many men and women of MGM, I want to thank you for providing us with an opportunity to be with you today. And I look forward to further questions today.
Thank you, Jim. We will be back to you later, but right now I'd like to ask Roland Hernandez to testify.
Can you check this mic? Is it working?
Okay.
Now it's working.
Apparently is.
Okay, would you like to, could I just move it, would that be easier on you?
This is the hard part.
Okay.
All right, thank you, Roland. First of all, why don't you start off by telling us about your background and your role at MGM.
First, let me say good morning, Commissioner Crosby, fellow members of the commission. It's a pleasure to be here with you today. So I have a long background here in Massachusetts. I graduated from Harvard College in 1975, concentrated in economics, graduated cum laude. I went on to Harvard Law School, graduated in 1982. I've served on the Board of Advisors for Harvard Law School since its inception over 10 years ago, currently sit on the board there. And I'm proud to say I have 2 children currently at Harvard, one a senior and the other a first-year law student. So my ties go back quite a bit. I also maintain a apartment in Cambridge. So I have a deep love and fond affection for Massachusetts, Boston, and Cambridge. I practiced law upon graduating from law school for a couple of years, then went into business. My first business position was at a global security company. Ultimately, I became CFO and head of strategic development. At that company, I did have clearance from the U.S. government, and that company, amongst its various operations, provides security protection to U.S. embassies and consulates around the world. So I opened up our operations, amongst other places, in Mexico City and all the consulates around Mexico. Spent quite a bit of time in that process. In 1995, I moved to Telemundo Group. Telemundo at that time was a publicly traded Spanish media company. I served as chief executive officer and chairman of the board at Telemundo, and ultimately was responsible for the sale of the company, and it was just a wonderful time at Telemundo. It was a great opportunity to provide news and services to a terrific population, the U.S. Hispanic population. We also did international news services and had production facilities throughout all of Latin America. I have served on a variety of boards, public boards of directors. I was on the Walmart Board of Directors, served as chairman of the audit committee for 9 years until my departure. I was on the board of Sony, based in Tokyo. Recently left Sony this last summer, and I was on the board of Ryland Homes, where I was also chairman of the board. Currently, I serve on 3 other public companies. I am chairman of the board of Orient Express, best known for its famous train between London and Istanbul, but also owns hotel properties in 22 countries across the world. I sit on the Vail Resorts Board of Directors, where I am lead independent director and serve on the audit committee. And I am also on the board of, let's see, I'm missing one here. U.S. Bank, yeah, they would not be happy with me. In fact, I'm leaving later today to go to U.S. Bank Board of Directors meeting. That's why I have to apologize for that. At MGM, I've been on the board since 2002. Approximately 1 year after I joined the board, I became chairman of the audit committee. I've served as chairman of the audit committee since that time. I am also lead independent director and serve on the corporate social responsibility committee. And as lead director, I work as a principal liaison between the board of directors and management, and have the opportunity to work with Jim Murren, the CEO, setting agendas and closely liaisoning with senior management.
As I said in my opening, one question that is relevant to the commission today is the response of the company to the Christensen matter and the remedial measures the company took. Could you describe the company's response to the Christensen matter?
Yes, I'd be happy to. Once it became clear through a Wall Street Journal publication and through communications we had from various state gaming regulators, there was an immediate reaction by the company. The compliance committee immediately went into action and commenced its own independent investigation. Separately, the audit committee immediately engaged. I recall that within a day or two of finding out, I flew to Las Vegas to meet with the compliance committee and sat in on the initial compliance committee meeting on this matter. Later, the audit committee created a special investigation that was ultimately delegated to a special committee, independent committee of the board of directors. I should point out here that critical to me as chairman of the audit committee was that we established an independent investigation that had complete integrity and was entirely walled off from any communications and/or influenced by members of the board, members of management, or anyone else who was touched by the inquiry. So we safeguarded the integrity of that process, took it very, very seriously. As the investigations proceeded, the Compliance Committee worked hand in hand with the Audit Committee. And as I will remind you, I think it's all in your binders, but the Compliance Committee is comprised of 3 independent members having nothing to do with MGM management or the Board of Directors. We also, the Audit Committee also had its own inquiry. 3 separate law firms were engaged, none of whom were at all involved with the company in any other matter in terms of the Audit Committee, and we did have gaming counsel that helped us in previous matters. Counsel for the committees reviewed over 4 million electronic documents, interviewed 41 witnesses, and put together an investigative report that ultimately was received by the Special Committee of Independent Members of the Board of Directors. Over a course of about 2.5 months, we met as a special committee over 7 times, and in December, 2.5 months later, we formed recommendations that we then delivered to the full Board of Directors of MGM. And those recommendations, of course, were acted upon later. And what were those recommendations? I would say that we viewed the matter as requiring 3 principal areas to be addressed. The first, I would say, was in the realm of legal issues and legal advice. And in that regard, I would say that it is certainly my expectation, and going forward will always be my expectation, that from your internal legal advisors and your outside legal advisors, you obtain quality advice, advice that has integrity, and advice that is fully independent. And as we had reviewed the matters with respect to the Trecinda situation, we believe that that was not the case at MGM. So our response on the legal side was twofold. The general counsel entered into a resignation agreement with the company. And I, of course, will say that the special committee was quite involved with respect to the parameters and the motivation for that resignation. Secondly, we recommended and effectuated a severance with our relationship with another law firm. And I will say that with respect to both those critical centers for legal advice, we believe there had been conflict. Unfortunately, we as a group of board of directors had relied on advice that we felt was independent and free of conflict. And as I sit here today, I can tell you that while it should have been apparent during the process that there was an independence and conflict issue, at the time we did not pick that up. So as a result, we did sever relationships with both those key legal advisory groups. The second basket of inquiry that, and redress that we came about was with respect to counseling. So we found that there were 4 individuals at the board or in management that had participated in actions that I will call reflected serious errors in judgment. And that was quite important to the special committee, and we felt that we needed to specifically address those errors in judgment, and we did. I personally was responsible in counseling each and every one of those individuals. Those counseling sessions were very specific and addressed the matters that we had uncovered, and we felt that they were appropriate in light of the circumstances. But again, I would say it was a very serious matter. I was delegated duty by the special committee to engage in those counseling sessions, and that work was done. And then finally, as a third matter, we engaged in what I believe were significant changes in governance of the company. And let me just quickly address some of those changes. First and foremost, we enhanced the communication between the company's compliance committee and the audit committee and full board of directors. So I'd like to insert here that the compliance committee very early on in this process had done, I believe, a very good job of identifying circumstances, conflicts, et cetera, with Mr. Christensen. Unfortunately, the communications between the Compliance Committee and the Audit Committee were suboptimal. And I can take responsibility for that as chairman of the Audit Committee, and I do so. We learned that this was an area that would require redress, and as a result, today, that communication system is much different. There is a member of the Audit Committee who sits on the Compliance Committee as a visitor to each and every one of their meetings. In addition, the chairman of the Compliance Committee reports annually, and the compliance officer reports regularly to the Audit Committee. So we think we have closed that gap of communication. Secondly, the position of lead director was instituted. Earlier in time, I was the presiding director. We beefed up the responsibilities that I had under the lead director position, and to this date, those are working very well. I regularly communicate with Mr. Murrin as chairman and CEO of the company, and we actively have a dialogue, including my participation in setting agendas for the full board of directors. Third, we are much more vigilant in watching for conflicts with outside law firms. There had been a law firm that had been advising the company for several decades. We've ultimately found that that law firm did not have the independence that is required to properly advise the company. We severed that relationship, but as a governance matter, it's something that we will never forget, and I think we look at quite closely these days. We next amended our code of conduct to address issues that were probably lapses, and we've decided that it was important to reinforce the code of conduct as well as education related to the code of conduct. We engaged in a much more disciplined review of the board of directors and the skill sets required of the board of directors, and coming out of that process, we did bring in a new member of the board of directors with significant regulatory and gaming background. We thought that that would be helpful for the company and did so. We also instituted a regular program for continued directors education that continues to this day. As recently as this month, we had training on AML, as well as we've had training on FCPA and other important matters. We think that we need to be best in practice in that regard. And finally, we adopted much stricter independence standards for the board of directors. So I could go on, but I think what I'd like to just leave this in terms of how we address this situation. We absolutely recognize the severity of it. There were lapses. We don't disagree that there were lapses. It is incumbent upon me as chairman of the audit committee to ensure that this committee and the company operates at the highest levels, highest standards possible. That is our goal. We are extremely vigilant in making sure that we complete and honor that goal. And as I sit here today, I will tell you that I think that the audit committee and the full board recognizes the importance of the responsibilities to which we have been tasked, and we do everything that we can to ensure that this company operates at the highest levels of standard.
Did the independent committee consider any mitigating factors?
Yes.
Be sure to speak to the mic.
Did the special committee of independent directors consider any mitigating factors?
So, I mentioned there were three areas that we addressed. One of them was counseling of the individuals that were involved in the activities. I will say that part of our assessment necessarily included the facts and circumstances surrounding the company and the environment at that time. So I'm going to address that, but I want to make it clear from the outset. I and the board of directors fully accepts responsibility for the activities, and in no way are they to be excused, and in no way are those types of activities to be tolerated going forward. So that's an absolute statement, and I will stand by that. Having said that, to respond to the question, I would remind the commissioners of the following circumstances, which were not insignificant as we looked at as to what would be the appropriate response to the activities and these errors in judgment. First, I would say that at the time, as I mentioned already, we recognized a gap in the quality of legal information we were receiving. So in particular, I would say that the general counsel of the company had a long-standing, pre-existing relationship with Mr. Murrin. This should have been much more closely scrutinized, but it wasn't, and unfortunately, we at the company placed heavy reliance on the general counsel's advice. As I say, I've been a member of many public boards of directors. That is appropriate to place reliance on the advice of counsel in legal matters. Here, that advice was not unencumbered. There were conflicts that should have caused us to not rely on that advice. But I think what I would tell you is just two quick things. When the board first heard of the matter, it was through the general counsel in a board meeting officially, and the first thing came from the general counsel's office was a public release that essentially invited the individual, Mr. Christensen, back to the board pending resolution of the matter. That should have raised a flag to us as to the quality of that advice. That was not good advice. That is not advice I would accept today. The second thing that happened that was unacceptable is that during the course of Mr. Christensen's criminal proceedings, general counsel for the company separately approached individual members of the boards of directors and asked for letters of support for Mr. Christensen. Again, highly extraordinary, something that I now view as inappropriate and shouldn't have happened, but should have caused us, amongst other things, to question the quality of that advice. I will say that Mr. Murrin was receiving that advice directly, we at the board directly, and unfortunately we were relying upon it. That was a mistake. I can tell you today that was a mistake. The second factor I would just generally raise is that in September of 2008, so we find out that Mr. Christensen, that this matter has happened, and it happens right at the time, September 24th is in the Wall Street Journal article is published, this is in the midst of one of the greatest economic recession since the Great Depression. It had a dramatic impact on the business of MGM, and we quickly found ourselves in the process of fighting for our various survival. So between the time of, let's say, September of '08 and the ensuing year, we almost declared bankruptcy. We fought that off. We were meeting as a board, as a member of the audit committee and chairman of that committee. I was having, I would say, weekly contact with management about issues involving the very survival of the company. Now, I am not saying that this is an excuse to be distracted from the very important mission of corporate governance and managing this company at the highest possible standards. It's not an excuse. It's simply the environment was a complicated environment that the board found itself in, and Mr. Murrin certainly was in the middle of operating the company in a hectic period of time. I would say that in addition to that, Mr. Lanny, the previous chairman and CEO of the company, resigned in November, the same fall. And Jim Murrin came in as appointed CEO in December, that same fall. So this is all within 2 months, within the backdrop of the possible bankruptcy of the company.
What year was that?
This was 2008. Yes, yeah. So this is complicated. But I have to say that there are absolute standards that boards of directors, companies need to adhere to. Those absolute standards would include complete compliance with all statutes and regulations, period. The fact that we had errors in judgment that occurred during this point in time, to me, is unacceptable. But it did cause us to make governance steps going forward. And I would tell you that it is my goal and objective, and certainly what I do every day as a member of the MGM board is to ensure that those things don't happen going forward.
Can I just ask, our questions are later, but I thought I heard you say, Mr. Hernandez, that there was a compromise in the quality of the legal advice because of a long-standing relationship with Mr. Murrin. Did you mean Mr. Krikorian?
Christensen.
Mr. Christensen.
Mr. Christensen.
Yes, there was, yes, I misspoke, I'm sorry. Yeah.
A longstanding relationship between Mr. Christensen and Mr. Murren.
No, so let me just correct the record. Mr. Christensen had been a member of the board of directors for a long period of time. Mr. Christensen was the named partner in a Los Angeles law firm.
right.
The general counsel of MGM was a named partner and had been a senior partner in that very same law firm. He then left that law firm to come to be general counsel of MGM.
Thank you.
That's the relationship I was
Thank you.
referencing. I have no further questions.
The Bureau has, is this mic working?
Yep. Oh,
The Bureau has just a few questions for Mr. Hernandez. Good morning, Mr. Hernandez.
Morning.
I want to focus just, excuse me. I want to focus just briefly on the role of the board and your role on the audit committee and compliance committee. Going back in time a little bit to when Mr. Christensen's indictment first became known to the board, and that's in February of 2006. Does that sound right?
Yes.
Okay. And I've read your sworn testimony and just had a couple of questions about your responses there. I take it that there was a board meeting that was not attended by Mr. Christensen that happened fairly immediately after the indictment was announced. Does that sound correct?
Yes.
Okay. And at that board meeting, from your testimony, from your sworn testimony, I understand that Chairman Lonnie made the announcement to the board that Mr. Christensen had been indicted. Is that fair to say?
Yes.
Okay. And you were asked, when you were interviewed by the investigators, about that board meeting, and you were asked whether there was any discussion at all by the board about the factual circumstances that gave rise to Mr. Christensen's indictment. Do you recall that question?
Yes.
And I believe you responded, no, there was no discussion of the facts underlying the indictment.
That is generally correct.
Okay.
That wasn't the entirety of the conversation, but that is generally correct, your statement.
Okay. And my question to you, Mr. Hernandez, is that, being on the board, and this was a board member, and learning that a fellow board member had been indicted, why wasn't there discussion at that point about what Mr. Christensen had allegedly done?
So it's a very fair question. Mr. Jacobs, general counsel for the company, was present. My recollection generally is that conversation was led by Mr. Jacobs. I generally recall that there was an admonishment that because there was a criminal matter being investigated, that they were not at liberty to discuss facts related to the case. And further, I do recall that Mr. Jacobs, as general counsel, then provided a set of conclusions, possibly to address the issue you've raised, but that set of conclusions was, as I would generally recall, that Mr. Jacobs represented that he was confident that this matter would be resolved in favor of Mr. Christensen, that they were very surprised by the allegations, that they did not believe these allegations bore any merit whatsoever, and as a result, the board should take great comfort in that conclusion, but we were not in a position, because of the ongoing criminal inquiry, to question the underlying facts related to the case.
Okay, thank you. That's helpful. There's a second board meeting, and it's a little bit unclear from your sworn testimony exactly when it is, but it's after this first board meeting, and it's after the indictment. And you described a conversation that took place, it sounds like immediately after that board meeting, because Mr. Christensen did come to this particular meeting. Do you recall that?
Yes, I do.
Okay. And you described that there was a discussion among the independent directors after observing Mr. Christensen at the meeting about whether that was a good thing or not. Do you recall that?
Yes.
Okay. And you testified in your sworn testimony that it was unanimous among the independent directors that it would be acceptable to have Mr. Christensen continue to attend board meetings. Do you recall that?
Yes, as part of a fuller conversation, yes, I do.
Okay. And I guess, let me just ask the same question again. At this point in time, was there any concern, and we put aside the regulatory concerns that might have been occasioned by Mr. Christensen's indictment, but was there any concern that based on this indictment and based on the limited facts you have, that his presence in the boardroom posed some significant risk to the company?
So let me answer as best I can, recalling the facts and circumstances at that point in time. When Mr. Christensen came to the board meeting and was present, it immediately caught my attention as a matter of governance because he was no longer a member of the board of directors. However, he had been Mr. Krikorian's longstanding personal attorney, and I also recognized that. Upon the conclusion of the board meeting, we did hold an executive session of the non-independent members of the board, which did not include Mr. Christensen, as he's no longer a member of the board of directors, or any members of management. And I don't believe during that meeting that Mr. Krikorian was present either. The first matter I raised was the presence of Mr. Christensen. I recall that immediately prior to that meeting, I had asked Mr. Christensen or Mr. Krikorian or one of the members who worked at Trecinda in what capacity Mr. Christensen was there, and I was informed he was there as the personal lawyer for Mr. Krikorian. So I took that information into the executive committee and expressed it as such, that we have the presence of an individual, Mr. Christensen, who has been asked by Mr. Krikorian to attend as his personal lawyer, and whether or not that was acceptable to the fellow board members. I believe that the decision was based to some extent on I would say personally, my decision was based on the fact that Mr. Krikorian was entitled to have a lawyer present. Mr. Christensen was still a practicing member of the California Bar, and as such, it was an appropriate request, and we so voted. And then going forward, Mr. Christensen did appear at other board meetings as Mr. Krikorian's personal lawyer.
Okay, thank you. Now, again, this is going back a while in time. In January of 2007, the New York Times published a very significant and lengthy story about the Christensen and Pelicano criminal matter. Does that ring a bell to you?
Not particularly, no.
Okay. Are you aware that in early 2007, the New York Times published some significant sections of the transcript of the wiretaps that were at issue in the Christensen-Pelicano criminal matter?
I do not specifically recall.
Okay. Do you recall during this period of time any discussion amongst the board members about the publication of the transcripts of the Christensen-Pelicano wiretapping?
I don't have any recollection at this point. It may have occurred, I just cannot recall.
Okay. The Compliance Committee, when it made the decisions about Mr. Christensen's, the parameters around Mr. Christensen's continuing involvement in terms of providing legal services and the like, it also decided that it would provide quarterly reports, I believe, to the audit committee or the full board on the progress of the criminal investigation. Is that fair to say?
There was a reporting requirement, and I think those reports were to go to the compliance committee.
Okay. And you were on the compliance committee at this point in time, correct?
No, the compliance committee had 3 independent members. I was on the audit committee.
I'm
which
sorry,
is
the
a
audit
separate
committee.
body.
Okay, pardon me. Do you recall any report being made to the board at any point in time in 2007 about the publication by the New York Times of the Pelicano Christensen wiretap?
Can you
But
repeat that question?
Do you recall any report being made to any to the board, or to the compliance committee, or to the audit committee about the publication by the New York Times in January 2007 of the Pelicano Christensen wiretap?
I don't specifically recall communication of that information.
Okay. Then you described in your, well, first of all, in late 2008, Mr. Christensen is in fact convicted of the wiretap charges that he was indicted for back in 2006, correct?
Yes,
Okay. And you testified that it was your understanding that following the conviction, and the sentencing, I should say, he really had no further involvement in the roles of, in connection with MGM, either in a legal capacity or an advisory capacity in any way whatsoever.
that's correct.
Okay. And then you described how in September of 2009, there's this article that appears in the Wall Street Journal. And that article is been marked and introduced as exhibit number 6. I don't know if you have a copy of it handy. And if you don't, we can
I
probably...
don't have it in front of me, but I generally recall there was a
Okay,
publication. of
okay.
that.
And the, and it sounded like from your testimony that this article did in fact get some significant attention at the board level at
Yes, it
at
did.
MGM. Okay. Now, the headline of this article is Judge Cites Kerkorian in Pelicano Case. Do you see that?
Yes, I do.
Okay. You were asked in your sworn testimony about whether or not MGM initiated an investigation of Mr. Kerkorian's potential involvement in the Christensen Pelicano wiretap matter. Do you recall that?
Can you repeat that?
Sure. Well, let me try. I'm going to try to characterize for you what you said in your sworn
Yeah,
testimony,
please.
and it'll save some time. I believe you said in your sworn testimony that you repeatedly asked Weil Gottshaw, was that the firm
Yes,
involved at the
representing
time?
the audit committee.
Okay. Whether MGM should investigate Mr. Kerkorian's potential involvement in the wiretap situation.
That was as a matter of scope, so just to put this within context, the special committee had retained its own independent law firm, Weil Gottshaw, and the special committee was involved in setting the scope for the inquiry in consultation with Weil Gottshaw. One of the matters on scope that we raised was whether we had a responsibility or whether it would be prudent to investigate the facts and circumstances around that.
Okay. And that included Mr. Kerkorian's potential, the possibility of his involvement in,
Yes, it
in this
did.
situation. Okay. And what the Wall Street Journal is reporting in September of 2009 is that the federal judge in the underlying criminal case had said that there was reasonable cause to believe that Mr. Kerkorian was in fact involved. At least that's what the article reflects.
Yeah, I can tell you that we had access by that point to the actual opinion that I recall was a ruling on an evidentiary matter that made a comment as not part of the ruling that raised a question that was not addressed, but raised a question in a theoretical manner, could Mr. Kerkorian have been involved in that sense? So it wasn't a judicial ruling, and we recognized it as such. We recognized, I think as everyone did at that point, that there was the possibility, but that the New York Times article and the opinion itself didn't provide any substantive facts to indicate one way or the next whether or not any violation of law had occurred.
Okay, fair enough. It raised a question, but wasn't conclusive.
Yes.
Okay. Did you ask Weil Gotcho at that point to review whether Mr. Krikorian was involved?
We asked them to check the record and provide us advice as to how we should properly view that matter and what their legal advice would be.
And
Yes.
what was their response?
So let me just check with counsel. Okay, just making sure, since those were deliberations within the committee and with its own counsel, and I'm not sure what privilege issues are raised. I think the answer is that we did receive information that they had looked at the matter, they had looked at the record, and that based on their own investigations, as the law firm's investigations, review of the record, that they could not make any their conclusion was that they had no information that would lead them to conclude that Mr. Krikorian had been complicit and/or involved in a wiretap.
Do you know if the team from Weil Gotcho had listened to the tapes?
I don't know.
Okay. Do you know, at this point in time, there was some significant litigation going on the civil side are you aware there was significant litigation at this point going on the civil side by Mrs. Krikorian against Mr. Pelicano, Mr. Christensen, and others?
We weren't, at the committee level, special committee level, we weren't privy to any of the pleadings and/or other civil activities going on in those cases.
Okay. I have no further questions.
I just have,
Yes,
excuse me, I'm
sorry, yeah,
do I wait to?
please,
do-
no, go ahead. If you're still on this same topic.
Correct.
Yeah.
Correct. Do you know if Mr. Krikorian was ever charged with a crime as a result of the Pelicano matter?
No, he was never charged with any crime.
You testified about the various corrective or...
Sure to use the mic, sorry, that it's not.
You testified about the various corrective and remedial measures that the company took as a result of this matter. Do you think they were effective?
Yes, I think they were effective. I'm confident we addressed the outstanding issues that have been raised by virtue of the Christensen matter. And as I said, it was both to address kind of the activities as well as to make sure that from a governance perspective going forward, we had created systems and controls where this kind of thing couldn't happen again going forward.
And how would you rate or rank MGM's current system of controls and procedures, including the compliance committee, the company's code of conduct and ethics, and other policies?
So I think I'd like to answer that in two ways. One, within the gaming industry, and then two, within what I will call U.S. publicly traded corporations. Within the gaming industry, I think we are by far best in class. We do things on the compliance committee by virtue of its independence, the communication now with the compliance committee and the audit committee, the systems and controls and levels of education, the way we delve into AML and FCPA that I believe is far beyond what we see with any of our competitors. With respect to public companies generally, I'm engaged with quite a few of them, and I would tell you that I believe we are best in class on a U.S. basis.
Thank you, Roland. No further questions.
Okay. I think before we go to the commissioner questions, we'll take a quick break, then we'll come back and pick up there. Commissioner McHugh?
Is he in the room? Oh,
Yeah.
there he is.
Okay, we will reconvene. No problem. We will reconvene. I apologize for the delay, and now ask the commissioners if they have questions for Mr. Hernandez or anybody else on this issue.
I do. Yeah, I have a couple of questions. Mr. Hernandez, you mentioned there were 4 individuals who did not pick up on the independence on this matter of the Christensen matter. You mentioned errors in judgment, and they were counseled. Who were those 4 individuals? I imagine maybe Mr. Jacobs was one of the 4 individuals?
Yeah, may we consult with your counsel for a second?
Sure.
Sure.
Yeah, thank you, Mr. Chairman, Commissioners. The names of the individuals who were counseled are contained in the report. That aspect of the report has been redacted.
Okay. Are those individuals still at the board with MGM?
So, just addressing the first point you made, Mr. Jacobs was resigned, effective almost immediately after the investigation was concluded. The 3 of those individuals continue to be members of the board of directors, and 1 other does not.
Okay. You also mentioned independent standards for the board of directors. Could you expand a little bit more on that notion, please?
Yeah, so we reviewed New York Stock Exchange independence requirements under the Securities and Exchange Commission rules and regulations, and we adopted those. We also enhanced those to make it clear that we had increased independence on the nominating and governance committee in particular. I think in that regard, we view the sanctity of the appointments of board members as important to protect against any possibility that there would be a conflict of interest involved in the governance of that committee.
Did you incorporate anything relative to having board of directors also come from outside counsel that you rely on?
So we formulated all of the new policies and procedures with the assistance of outside counsel, but there is not a requirement that a lawyer be on the board, if that gets your question.
Or that your outside counsel firm be precluded from having a member in the board? Is that a requirement or not a requirement?
There's not a requirement, but I can tell you, as a member of the board, that I don't believe it would be appropriate to have a member of one of our outside legal advisors be a member of the board. And that certainly would not compel that.
You also mentioned, talked a little bit about the compliance committee and the audit committee and how that communication was enhanced. You mentioned there's one member of the audit committee that you chair. Is that correct?
Yes.
You chair the audit committee?
So I chair the audit committee. A member of the audit committee is also responsible for attending in person the compliance committee meetings, and he does so at each and every compliance committee meeting. Annually, the head of the the chairman of the compliance committee attends at a minimum 1 session of the
How about the board of directors? How do they hear, from both, from either, or one?
They would hear from the audit committee. So during my regular report to the full board of directors, I would include in that reporting matters which would have come from the compliance committee's presentations. In addition, the general counsel will also report on matters of compliance that are significant to the full board of directors. So there are two controls that are operating.
You also mentioned the lead director role. Is that the equivalent of the chairman of the board?
It's not quite the equivalent of chairman of the board. So the chairman Mr. Murray has all the duties and responsibilities that we typically associate with the chairman. I would say that this is a role that creates a formal liaison between the chairman of the board and the independent board directors. Let me give you an example. At the conclusion of every board meeting, we excuse any management members of the board, including the chairman, and we as independent directors meet amongst ourselves and discuss any topic that we believe is relevant. We also have an ability to invite in our own advisors into those closed-door sessions. As a product of those meetings, if there's something that we think needs to be taken back to management, I, as the lead director, have a meeting with Mr. Murrin, and we communicate those findings anonymously. So we protect the integrity of the discussion. We make sure that each and every board member has a full opportunity to be critical of management if necessary, or to make comments that they would otherwise feel uncomfortable in a full session of the board of directors. And there's a mechanism whereby I report all of the findings, all of the minutes of those meetings to the chairman. The view is that there are certain things that are difficult to address in front of management, but nonetheless need to be addressed. And I think that what we have found coming out of this entire set of circumstances with Mr. Christensen is that the integrity of the process needs to be complete. And as part of the integrity of the process, you need information, full information. Oftentimes that's from outside advisors. So we do have the ability and do hire outside advisors where we think we want complete independence. With that full information, on the process side, what we do is we protect the quality of the discussion so that the members of the board who, by definition, at certain points in time, have a tension with the views of management. That's why we're there. We provide oversight for the company, oversight of the management. We make sure that we protect the quality of our own discussions, and the product of those discussions is communicated and acted upon. So as the result of some of our executive sessions, Mr. Murrin will be invited to report to us as to progress on issues that he has been tasked with reviewing. So we think we close the circle, but I want to emphasize this notion of independence, a built-in tension, recognizing that the board of directors is not managing the company. We oversee the company, and when management does something that we have any issue with, it's our responsibility to get back to them and to correct that action or to ask questions.
So, how is that lead director designated? For how long
It
is
is,
that position held?
I am appointed by the board of directors annually.
Also, I was listening to your background, of course, with interest. It's very impressive being involved in so many, or a few very complex, large companies is probably quite a task, or set of tasks. Do you worry that in your role you are at such level that you may lose sight of some of the details or nuances that are sometimes contained in the decisions that you have to make or contemplate?
Well, it's what I will call an active concern, which is that I know that there are many, many details about MGM as well as these other companies on which I serve, and my responsibility is to do the reading, do the studying, engage in the conversations, engage with other directors, engage with management. That's the job. And if for a moment I thought that I couldn't complete those responsibilities, I wouldn't do it. So it's something that you need to be vigilant about. But again, I would tell you that hard work, like many things in life, studying all the material and knowing the company well, and I believe I know the company well. The other thing I should point out this time is that while we've had conversations about some of the issues that arose on the Christensen matter, I want to point out that my job is made easier because of the cooperation of management. And this is something that wasn't addressed, and it's important that I mention this. When we created the special committee on the matter to review the Christensen matter, I went into Jim's office and I told Jim that he would be 100% walled off from this discussion. Now, that's the CEO and chairman of the company receiving information that he cannot participate in a very important matter that affects him personally, his role as CEO and chairman of the company, and the company itself. My job was made significantly easier because of the support of Mr. Murrin. And he basically, what he told me was, you at the special committee, do what you need to do to ensure the quality of this investigation. I want this investigation done. And it's that kind of support that makes life as a member of the board of directors and chairman of the audit committee significantly easier. And it's, so while I talk about this tension, and there is a tension, there's no doubt about it, I will go into Jim Murrin's office oftentimes and address issues with him, and he probably doesn't really like the fact that I'm having those kind of frank conversations. On the other hand, it's a collaboration, and I think the best companies are run collaboratively so that the information, the independence, the views and oversight of the independent members of the board of directors is received and welcomed by management. And I will say that Jim has done an outstanding job. The entire management team understands and respects the integrity of the process and governance and works well with the board of directors in terms of driving this company forward. So there is a tension, but there's a collaboration that works well. And I think we're doing a good job, and we'll continue to work hard to do that job.
Mr. Stebbins?
Mr. Hernandez, thank you. You mentioned in that long list of corrective steps that the company took, you mentioned reinforcing the code of business conduct. Could you tell me what reinforcement meant, measures you might have taken or additions you might have made to the code of business conduct?
Yes, so there are significant changes that we made, and I might leave it to general counsel to give you that long list. I will tell you that in terms of policies and procedures, there are several areas that I think that we did not do as well as we could have and as well as we are doing now. The first I would call training. To have the policy in place is not particularly helpful if the key individuals in the company, including members of the board, have not been trained into the particulars of those policies. We do a much better job these days than we did, and I think we learned from some of our errors in judgment there. The second, what I would call the communication of the process and procedures. So people need to understand that there are procedures in place when and this one directly in response to your question, when a conflict of interest arises. I should say nowadays, we have a well-clarified policy with respect to any potential conflict of interest. It goes through the compliance officer's office, it goes up into management, and if there's a lack of unanimity around any matter that involves a conflict of interest, it goes to the audit committee and to the board of directors. So when I say lack of unanimity, what I mean by that is if there is a matter that the compliance officer does not 100% agree that there's an absence of conflict, or it then goes to general counsel and senior management. And if they cannot completely agree, if there's one abstaining member, it goes to the full board of directors. Some matters go to the full board of directors automatically. There's zero reliance on general counsel or compliance officer. Those would be Section 16 officers, for example, key reporting officers in the executive committee or management of the company. If there's a conflict of interest, it will go directly to the audit committee. The reason that is so important is because the audit committee is comprised of fully independent members of the board. So again, we're protecting the sanctity and integrity of the process for oversight.
Is the code of business conduct a requirement of every level of employee, all the way up through management and the board?
Yes. Is reviewed and signed.
And there was obviously an existing code of business conduct in place before the events relative to Mr. Christensen.
Yes, there was.
Are they periodically updated, reviewed? Is there somebody with responsibility to make sure that the information and the requirements are timely?
Yeah, very fair question. There was a code of conduct. We've made improvements, as I've stated. Today, if there was a regulatory requirement that had an impact on the code of conduct, it would immediately be updated. Beyond that, there are annual reviews of all our policies that are in place. So recently, in December, we updated some of our codes of conduct because we felt that we, in fact, could even tighten them further, and we did so.
Commissioners?
Just a couple questions. Good morning, Mr. Hernandez.
Morning.
I was interested in your statements regarding this second recommendation, judgment, and you personally did some counseling, is that correct?
Yes.
Do you have training in counseling, or how did that train? I know that we're not going to really talk about names. I'm not interested in names, but what kind of training or counseling did you provide?
I will say that the entire matter became very formalized because we recognized the severity of a lot of the actions involved. With respect to the counseling, we had the assistance of outside advisors, and in particular, an outside law firm with a significant resume in corporate governance advice. They came to us working collaboratively with the special committee and developed a specific set of recommendations for the counseling. So it was not, I want to be really clear here, it was not an ad hoc, oh, I think you had an error in judgment, don't do that again. That was not the situation. There was a specific list of points that I was tasked with giving to the individuals to whom I counseled. There was a discussion, a Q&A, but it was quite developed and elaborate, and it was received by the special committee upon advice of an outside law firm.
Thank you. And just wanted you, in addition, to elaborate on, you mentioned in an executive session that you brought up Mr. Christensen's attendance, continued attendance after he was no longer a board member. Was that you personally who brought up that issue, and did you see a problem, or was it a general discussion? How did that come about?
At that time, I would have been presiding director of the lead independent of the independent directors. I did bring that matter up to the independent members of the board and led that discussion. There was a discussion or dialogue amongst all board members, and we ultimately concluded that it would be acceptable.
You just mentioned to a previous question, you responded that because you're independent, you're now able to address those, or you do a better job addressing some of these issues that are around conflict or any other issue. Would it be fair to say that, I mean, you certainly were independent before the Christensen matter as well, but do you take on those responsibilities you see a need to improve or to strengthen your role in this as the chair of the audit committee?
I think that we learned a variety of things, and we grew from it coming out of this set of circumstances. One, as I've mentioned earlier, is that we did not question hard enough the quality of the independence of legal advice. And while it is typical that a member of the board can rely upon outside legal advisors, here there were red flags we should have picked up. And I can tell you that we are much more sensitive today to the quality of that advice and to the selection of outside law firms. Now, the selection of outside law firms is something the management does, but in this situation, if management were to make a selection of outside law firms that the independent members felt was inappropriate, they would hear from us. And I think that is much different. I will tell you that we were exercising independent judgment back in 2008 2008 and 2009, and we take our job seriously. With respect to that particular executive session and our acceptance of having a legal advisor to Mr. Krikorian, I think today we would think long and hard about that particular set of circumstances and question more fully why a member of the board needed a legal advisor, and whether, if in fact a legal advisor was necessary, whether that individual should continue sitting as a member of the board of directors. So it has caused us to be, to scrutinize much more deeply things that at the time we accepted as appropriate.
Okay, thank you.
There was a code of conduct in place when these events were transpiring.
Yes, sir.
Was there not?
Yes, sir.
And the code of conduct dealt with the behavior of all employees from top to bottom.
Yes, sir.
Isn't that right? And the way that this particular matter was handled violated that code of conduct, did it not?
There were violations of the sharing of confidential information, in particular, that were violative of the code of conduct. Yes.
And now there's a revised code of conduct.
Yes, sir.
And the revised code of conduct contains, I take it, matters that were in the original code of conduct plus others.
That's correct.
The conflicts that you mentioned on a couple of occasions involved essentially Mr. Christensen, who was legal counsel to Mr. Krikorian. That's one element of it. Is that right?
Yes, sir.
And he was also a named member of the law firm that was representing the company. Is that right?
Yes, sir.
And he was also one who had a long-standing relationship with Mr. Jacobs, the general counsel. Is that right?
That is correct.
So that was three components of the conflict that you've been referring to on several occasions. Is
Yes,
that right?
sir.
Why wasn't that conflict evident to everybody who looked at it contemporaneously?
Well, I would say, let me start by saying that I had recognized that there was a conflict, at least the appearance of a conflict, appearance of impropriety, given the relationship between the law firm and members of the board, Mr. Christensen, and the general counsel who was of counsel to that same law firm. So early on at MGM, in my capacity as chairman of the audit committee, I did speak specifically about this matter to the chairman and CEO of the company, Mr. Lanny. And I told him at that meeting that I was concerned about the possibility of conflict. Mr. Lanny reminded me that that is a management decision in terms of selection of outside counsel, and that he reaffirmed to me that it was his desire to use that law firm for the company. He did say that he would continue to monitor the situation closely. I also continued to monitor the situation, but I will say that having raised the issue, I did not insist that management make a change. That would have been extraordinary. In retrospect, I should have. Going forward, even though I was aware of the possibility of conflict, when the Christensen matter developed, I should have recognized some of the early warning flags better, and I did not. In conclusion, what I would say is we've learned that this conflict with outside law firms is a critical matter, and we've taken corrective action.
I'm not so much concerned with that specific incident as I am with a general approach to difficult situations. So you had this discussion with the chairman, and that was the decision made at the time. But then when Mr. Christensen was indicted, there was, from the Compliance Committee, a recommendation that he be removed as the MGM billing partner from the law firm that he was associated with, that he have no further involvement in MGM litigation, and that he, his firm bar him from further consultation on MGM matters. That was what the Compliance Committee at the time initially recommended, was it not?
Yes, sir.
And did that come to the board? Those recommendations come to the board?
No, unfortunately, those communications, as you've described, did not come directly to the board. They were in a written record.
I'm sorry?
They were in a written record that was available, but that was not a matter that was actively deliberated upon by the full board of directors.
And what, it was a record available to the board, but could you amplify on that a little bit?
Yeah, so the Compliance Committee's minutes and record of their proceedings is available to the board. But here, at that point in time, you had Mr. Jacobs as general counsel, who was serving as the principal, I'm going to characterize this as my understanding, he was the principal liaison or point of communication between the board of directors and the Compliance Committee. And unfortunately, as I've addressed earlier, I think that he was hopelessly affected by conflicts and independence issues that ultimately affected the quality of that information flow. We dealt with that, too late, obviously, but it was dealt with, and he left the company, resigned from the company. Since that time, we have modified the communication procedures between the Compliance Committee, the Audit Committee, and the Board of Directors.
And now there is a requirement that the board review Compliance Committee minutes and the Compliance Committee review Board and Audit Committee minutes, right?
Yes, sir.
And that policy was put into effect in November of this year, is that right?
Yeah, I think that was done earlier than that. There were additional changes made in November of this year, but the governance changes that we adopted vis-a-vis enhanced communication with the Compliance Committee, it's my recollection that those occurred shortly after the ultimate determinations on this matter, which would have been December of 2009. So during 2010, those should have been put into effect.
They were part of the recommendations that came out of the 2009 investigation?
Yes,
to
sir.
the best of your recollection. Going back to the recommendations that were made by the Compliance Committee in 2006, somebody suggested to the Compliance Committee that they were too harsh, and as a consequence, they were changed, and Mr. Christensen remained as the billing partner, and he was not permitted to be the lead counsel in litigation matters, but was permitted to give advice on matters of importance to the corporation. Is that right?
Yes, sir.
And was the board advised of that contemporaneously? Or was that the same circumstances as the initial recommendations?
Same circumstances, unfortunately, yes.
And after Mr. Christensen was sentenced on November 14 of 2008 and lost his license to practice the same day, he continued for another 13 months to participate in giving advice when requested to MGM. Isn't that right?
So the record would reflect that he had continuing communications. Those communications were, the board of directors did not have visibility into those continued communications, and it was not until much later that we understood that that had happened.
Didn't he attend board, at least a board meeting after his conviction?
No, sir, he did not.
Even by telephone?
Let me be clear. The record now reflects that he attended a board meeting telephonically. The independent members of the board of directors were not aware that that occurred. He was not announced on that telephone call. So yes, it did occur. I want to be clear about the knowledge of the independent members of the board of directors.
And who was responsible for making arrangements for that to happen?
So I'm happy to respond, but maybe let me ask first the lawyer to respond as to whether there's any redacted parts of that record.
Go ahead, Ron.
It's my understanding that the presence of Mr. Christensen, his presence was in the offices of Trecinda Corporation, and that he participated, or at least was present and heard the deliberations, at least some portion of the deliberations of the members of the board of directors.
And my question was, who arranged for that to happen? Was that in Mr. Krikorian's office?
Yes, so Trecinda is Mr. Krikorian's company, and I don't specifically know who arranged it. I am aware that I now understand he was there in their offices in a room as part of the telephonic meeting.
It is fair to say, is it not, that the continued presence of, and say, let us call it deference to, Mr. Christensen, after his troubles began, was in significant part because of his perceived relationship to Mr. Krikorian?
So let me, if I could answer that from the perspective of lead independent director, chairman of the audit
Right.
company, and independent member of the board of
Right.
directors, there was no continuing association. So there was no level of activity that was appropriate, understood, or tolerated.
I'm talking about after his troubles arose, from the time of his indictment through the time of his conviction. He did participate,
Yes, he did,
visibly.
as a legal advisor to Mr. Krikorian, yes.
Right, and that was tolerated. I'm asking you if it's fair to say that that was tolerated because of his perceived relationship to Mr. Krikorian.
Speaking individually,
Yes.
I will tell you that it was acceptable to me only within the context of a legal advisor advising a member of the board of directors. Said a different way, and I did ask the question specifically on this matter. Had someone told me, well, he was a member of a board of directors, he's a close associate of Mr. Krikorian, and therefore wouldn't it be appropriate for him to be in the board meeting? The answer is absolutely not. It would not be appropriate. However, as a legal advisor, again, sitting member of the California Bar, within that context alone, and I should say that this is important because in the context of a legal advisor, he's not engaged in the dialogue of the board meetings, he's not responding to matters, he's listening to matters, presumably to advise his client. And so his participation in the board meetings was limited to his presence. It was not as an active contributor inside the directors' meetings. So I hope I.
No, I understand what you're saying, but you're not saying, are you, that any other board member who wanted to have her legal advisor present, either while she was present or in her place, would have been permitted to do so?
There was an instance where Mr. Haig made the same request, General Haig, who's since deceased, and that was approved also. it would no longer be approved.
So it was a common, but it wasn't a common practice?
No, it was not a common practice.
I'm asking these questions because it is clear that the company has taken significant remedial steps since the events occurred. But remedial steps are only as good as the people that enforce them. And how can you internally, and how can people externally looking at the company be assured that under the same kinds of circumstances, a relationship between a important investor, a difficult financial set of circumstances, other vicissitudes that are bound to affect corporations in all walks of business life, those same circumstances won't produce the same kind of result again?
So I would ask that you accept my assurance that never again would I ever tolerate any conflict or appearance of conflict of that nature. And I feel it'd be incumbent upon me to raise it first to management. And if management was not willing to accept that opinion, then I would take it to the full board of directors, and the full board of directors would exercise its responsibility to correct that. We learned a lot here. And I believe that what I can represent to you is that our compliance procedures right now are as best as I've ever seen in any organization. Everyone on that board understands the critical nature of exercising independent judgment. That independent judgment does not need to be popular. In fact, it's most important when it's unpopular, and that's our job. And the moment any member of this board would ever do anything that I saw as inconsistent with those standards, I would ask that that member of the board of directors be removed.
All right, sir, thank you.
There is a reference in the report to the compliance plan. Is that an exhibit? Do we have the present compliance plan?
I'm not sure.
Yes?
We do.
There's a lot of
It's not an
exhibits, I'm
exhibit.
not sure.
Not an exhibit to this
I'm
hearing, but
sorry,
I,
not an exhibit, I meant an attachment.
Yes.
Yeah, so we do have it in most, okay. This is, you've probably explained this, and forgive me if you have, but I don't quite understand the interplay between the compliance committee and the audit committee. You can talk about if there's a significant conflict that goes to the audit committee. I would have thought that's what the compliance committee did. So what's the fit there?
So the compliance committee is appointed by the audit committee. There are 3 members. They're fully independent from the company. There is a chairman that we elect annually. The audit committee elects that chairman annually. And then on a rotating basis, the other 2 members are elected every 3rd year, so that's a rolling 3-year membership. The compliance committee is tasked with a review of compliance with gaming regulations and other matters, operational and orientation. For example, the approval of vendors, the approval of any individual that needs to be licensed before any of the gaming regulators. And as such, they oftentimes will come across a conflict issue. That is handled by the compliance committee. I did mention that there's a separate conflict issue that goes straight to the audit committee. But on typical matters, operational matters, vendor clearance, for example, that's at the compliance committee. We at the full board, they operate independently of us. And so those recommendations, they are tasked with that compliance business. There are certain matters that if they have disagreement or lack of unanimity, will then go to the audit committee and full board. So I'm not sure.
Yeah, that's helpful, thank you. Mr. Murren, Mr. Hernandez, could you, somebody shut that door, there's somebody around. Mr. Hernandez has been very definitive about his judgment of his own behavior and judgments during that period of time. how do you look back on your own behavior and judgments during that time?
During the time in 2009, or how far back, Chairman?
Well, from the time you got in, I forget the exact dates, but it started in '06, right?
Yes.
And then all the way up through into the time when the special report was undertaken.
I would view my actions as inferior to the set of standards that I hold myself to. From the moment Mr. Christensen was indicted through and up to the point where I became the chairman and CEO at the end of 2008. As Roland very comprehensively articulated, our company as a board, and I was a board member at the time, though not the chairman and CEO, should have done more. And I, as an individual board member, when I was the CFO of the company, should have done more, should have questioned more than I do today. I would reiterate everything that Roland said, and I agree with Roland's perspective on the events. Roland Hernandez and our other individual board members are extraordinarily rigorous, very intelligent, and very engaged in our company. And when I became the chairman and CEO at the end of 2008, I became far more focused on the issues at hand, which were an attempt to save the company. I don't think it could be underestimated how dire our financial situation was when I received this promotion, such as it was at the end of 2008. And my focus was where I believed it should have been, which, given my banking background, was an attempt to finish the largest project under construction in the United States, to keep 10,000 construction workers working, to keep morale at some level, low as it was at the end of 2008, and to focus on, with my CFO and my great financial team, the efforts of attempting a recovery at MGM Resorts and at City Center. I am bitterly disappointed in myself, in my actions, and I'm happy to go over all those with you, but I would concur with Mr. Hernandez's perspective on the events. We are a better company for it. I believe I'm a better executive today than when I was thrust into this situation abruptly at the end of 2008. And I, as a former Wall Street analyst that used to cover many, many companies, would concur with Mr. Hernandez. I believe that today, though not then, today we are the gold standard from a regulatory and an independence and a governance perspective.
Thank you. Other questions? Ross?
I do have a series of questions for Mr. Murrin, if this is appropriate time.
On this,
Was he going to do sort of a direct examination first?
Right.
Yeah.
right, this is read on a new topic, right. Yes, sir. Well, yeah, it's 12:10. Should we
Yeah,
go
Mr.
ahead?
Hernandez needs to
Oh,
leave.
Mr. Hernandez needs to leave, right.
If I could ask for your permission to be excused, I have till 12:30. I'm happy to answer any other questions you might have.
Go ahead.
I have one more question. It appears there was some deference to Mr. Christensen's involvement based on his institutional knowledge of the business. Do you think you would have treated a board member who, say, had been on the board a less period of time, 3 or 4 years, any differently?
I think his significant institutional knowledge of the transactions and the business of the company was a factor that we considered when he was, after his indictment. I think there was a recognition, particularly on this matter, this legal matter, his continuing involvement in his firm, that there were services that he could provide to the company that were beneficial to the company. And I think that was unique.
Thank you.
Is there anything else that is of particular, your role in particular, either Mr. Mackey or that you know of, that you'd like to speak to before you go?
If I could, with your permission, and again, I apologize for having to depart early. I had a pre-existing board meeting. I've now recalled which company I have to go off to. I just wanted to mention that this matter on our governance vis-a-vis Macau is something of the highest level of oversight on our audit committee. And so it is, I want to stress that it is something we actively engage in, and I know we will handle this separately with you. And there are individuals that will get involved and testify as to specifics of AML, FCPA, collaborators, if you wish, junkets, et cetera. But from an audit committee, an audit chair perspective, I just wanted to give you a sense of our oversight of a significant subsidiary of the company. It is important. We recognize it's in a foreign jurisdiction. It's a long ways away. And because of those reasons, we need to be extra diligent in oversight. And so I want to provide you just 7 quick elements of that oversight program, just to give you a sense. I'm not trying to shorten this conversation about MGM China, but really before I leave, at least offer from the audit committee's perspective the things that we look at. So the first thing I would say is that the audit committee itself directly engages with the audit committee of MGM China, which is an independent publicly traded company on the Hong Kong Stock Exchange. I've personally gone to Macau, continue to go to Macau, have visited with the chairman of the audit committee there, and there's a close set of communications. We will go annually, it's our intent to go annually to Macau, some member of the audit committee, to visit with the audit committee in Macau. That's an ongoing initiative, and we think the communication is critical in that regard. Secondly, we take some comfort that the 12 members of the board of directors of MGM China, 6 of them are members of MGM Resorts. We therefore have a direct flow of communication as to the board making decision. I personally communicate with Mr. Marin about issues that he sees in MGM Macau, and we ensure communication flow that way, which is board information to audit committee. Thirdly, Deloitte & Touche, our outside auditors, audits MGM China as well as audits MGM Resorts. Deloitte & Touche, at the audit committee, we inquire of them specifically as to what they are doing in China. They have represented as recently as 2 weeks ago to me that they have outstanding visibility into the financials, the controls, the SOX performance at MGM China. That is reported to our audit committee from Deloitte & Touche, and again, they represent that they have outstanding access and visibility to all of that financial information. Next, I would say that MGM China has a compliance committee, similar in nature to the compliance committee we've spent so much time discussing today. There are 3 members of that MGM China compliance committee that are U.S.-based that also come back to MGM Resorts and report to us as to the proceedings or significant findings that compliance committee has seen in China. So again, the compliance committee communication does come back to the United States as well. Next, I would say internal audit, MGM's internal auditors. Now, these are individuals, the head of internal audit, chief audit executive at MGM, reports directly to the MGM audit committee. So we have direct reporting with him. He, in turn, has direct communication with MGM China and makes multiple visits to MGM China to work with the MGM China Audit Committee. So this occurs on a continuing basis throughout the course of the year. That head of internal audit reports directly to the Audit Committee, including every session of the Audit Committee and executive session, where he is there alone reporting to the members of the Audit Committee, all independent, free of any intrusion of any member of management. So again, I'm comforted that there is strong individual reporting there. Next, I would say that financial data by our finance team, Jim's finance team, they receive the reporting directly from MGM China, so there is strong visibility into all the numbers in China. They do come to the United States, to our finance team. They come to Mr. Dorigo, ultimately, who sits on the MGM China board. And as CFO of MGM Resorts, Mr. Dorigo is regularly in the U.S. the U.S. Audit Committee meetings and has an opportunity to present to us, including an executive session where there is no other member of management involved. And then finally, as you will hear later today from Mr. Medford, who's Senior VP of Global Security, he also has heavy visibility into the conduct in MGM China, regularly is out in China, and he too reports back and can report to the Audit Committee whenever we so desire, and is tasked with reporting significant matters to us as necessary. So I don't want to belabor that too much, nor do I want to shorten the ultimate conversation, but I did want to communicate to you that this is something that is quite significant. It is a role that the committee is overseeing, critical in terms of the quality of our compliance globally, and I think we're doing a fine job, I will say, with respect to this matter, which is governance and control over a foreign reporting subsidiary in Macau. I think we are best in class.
I just have one or two questions on that summary. You have a compliance policy for MGM US that applies to all the US entities that MGM operates, isn't that right?
Yes, sir.
And there's a different compliance plan and policy for China, isn't that right?
Yes, it is a independent Hong Kong listed company.
Right.
Yes.
But the terms and provisions of that compliance plan for China are different from those in the United States.
My understanding, and council can elaborate, are that they are generally consistent and were built off of the MGM US compliance plan.
All right, well, we'll explore that later. Thank you.
Anything else for Mr. Hernandez? Thank you very much for your time. Appreciate your coming to Boston.
Been my pleasure to be here with you today. Thank you.
Shall we take a